One of the things that you may not all know is that there is a special committee in the United States Senate that is dedicated to Indian affairs. The Indian Affairs Committee is currently chaired by Brian Schatz of Hawaii, and we are honored to have as the moderator for this panel the Majority Staff Director, Jennifer Romero Monaco. Jennifer will be serving as the interlocutor for the panel and introduce our distinguished guest. I do want to acknowledge that for those of you who are looking at the program, we had intended to have Elizabeth Haldego-Reese. She was very excited, and we heard from her just the other day that she has experienced a medical emergency and is unable to travel. And so we wish her all a speedy recovery, and we will find a way to share her scholarship in this work in another way. We may have a webinar with her, so stay tuned to see how we're gonna get that piece. But this gives us an opportunity to hear even a little bit more from John Echohawk, which will be extra special. Let me tell you about our moderator, Jennifer Romero Monaco. She previously served as a senior advisor for Native Hawaiian Affairs at the United States Department of Interior. She's been a House staffer and a lawyer. She's an alum of Princeton University and the American University College of Law. So we are honored to have the staff director serving as our moderator for today. Jennifer.
Good morning, good afternoon, and thank you for that really generous introduction. I appreciate it. And thank you to the Capital Historical Society for bringing us all together today to talk about Native American suffrage. Again, my name is Jennifer Romero. I go by my maiden name, Romero, professionally. Did marry an Italian man with a Monaco last name, and I think it has a nice ring to it. But anyhow, nice to see everyone this morning. I am the staff director and chief counsel of the Senate Committee on Indian Affairs, working for Chairman Brian Schatz, the senior senator from Hawaii. Again, I've really just dedicated my career to advancing American Indian and Alaska Native and Native Hawaiian affairs, both as a practicing lawyer and now as a public servant. So it's really my honor to be here today to moderate this panel and really have a conversation with John Echohawk. Let me introduce him. It might take a while because while my introduction took about 30 seconds, his might take a little bit longer than mine. John and I go back quite a ways, actually. One of the first internships I did as a law student was with the Native American Rights Fund here in Washington, D.C., and that was when I first crossed paths with John. So it's been some time, and it's just been wonderful following as my career developed and really seeing him as someone to look up to. And he's done so many incredible things throughout the course of his career. But let me just start out with acknowledging that Mr. Echohawk is Pawnee, and he's the executive director of the Native American Rights Fund. It's the oldest and largest nonprofit legal organization defending Native rights. He was the first graduate of the University of New Mexico special program to train Indian lawyers and was the founding member of the American Indian Law Students Association while in law school. He's been with NARF since its inception in 1970, and he's served continuously as executive director since 1977. He has been recently recognized as one of the 100 most influential lawyers in America. This is pretty awesome. By the National Law Journal, and has received numerous service awards and other recognition for his leadership in the field of Indian law. He serves on the boards of the American Indian Resources Institute, the Association on American Indian Affairs, the Indigenous Language Institute, Natural Resources Defense Council, and the National Center for American Indian Enterprise Development. Mr. Echohawk attended the University of New Mexico where he earned his BA and his JD. So with that, just if you allow me a personal note, I am originally from New Mexico. I'm from the Pueblo of Santa Clara. It's a small tribe, about a half-hour north of Santa Fe. If anyone has ever been there, please come visit, contribute to the tribal economy. Mr. Echohawk, again, it's a privilege to be here with you today, and you have the floor.
Thank you, Jennifer. I'm very honored to be asked to participate in this symposium here today. It's a really special occasion. 100 years ago, the Indian Citizenship Act passed, and it's really great that that's being commemorated here. We have come a long way since that time, and we at the Native American Rights Fund have played a key role in that. It's something I got involved in just kind of by happenstance. I was, even though I'm a citizen of the Pawnee Nation of Oklahoma, I was born and raised in New Mexico, in the Four Corners area, Farmington, New Mexico, and I did well in school, and I got encouraged by some of my teachers there to think about being a lawyer. I had been elected president of the student body there at Farmington High School, and just a few Indians at that high school, mostly non-Indians, but still, I got elected. And some of the teachers said, "You really ought to think about being a lawyer." So, okay, well, I'll go to college and put in 4 years and get ready to go to law school. So that's what I did. Went to school at the University of New Mexico, and when I was a senior, getting ready to graduate, I went over to the law school to make sure they got my application, and also get some scholarship information, because I had a scholarship to go to college, academic scholarship, needed one to go to law school if I got admitted, and went over there, and they looked at me and said, "You look like an Indian." I said, "Yeah." And they said, "Well, do you have a minute to meet with the dean?" Oh, I'm already in trouble, not even admitted. What is this? And so I went in and met with the dean of the law school, and he told me that they had just been notified there at the UNM Law School by the Office of Economic Opportunity, conducting that war on poverty, that the law school had been asked to administer a scholarship program for Native Americans to go to law school. And so the dean asked me if I wanted a scholarship. Sure, just right place, right time. And to the credit of that law school, they put together one of the first courses ever taught in federal Indian law. This was 1967, one of the first law schools ever to do that. And it was very fascinating to look at this federal Indian law, and the other Native students that I started to go to law school with, they didn't know much about that either, and we realized that our tribal leaders didn't really know much about this either. And then we find out about the legal process. Well, it's all about the law, but unless you have lawyers to enforce that law, then that law just really is no good, doesn't exist, doesn't mean anything. And our people were the poorest of the poor. We didn't have any lawyers. And so we observed what was going on around us there in the late 60s, and that was the civil rights movement, and black people advocating for equal rights under the laws of this country to be free from discrimination. Of course, that was the law, and they were poor. They didn't have money for lawyers, but they started this NAACP Legal Defense Fund, a nonprofit organization raising funds, hiring lawyers, and making them available to represent black people in these civil rights cases. And of course, they were winning and changing everything. And so we kind of noticed that, and figured out that what we ought to try to do, if we could to get through law school, is to try to organize a national Native American nonprofit organization to raise money, hire lawyers, and make them available to represent our people on our Indian rights issues. We had seen how that had some success through another program there at the Office of Economic Opportunity starting at that time, and that was for the first time legal services offices being set up across the country to serve poor people. And some of those programs were set up on Indian reservations. And all these young lawyers from Harvard and Yale going out there starting to work for the Indians, and they didn't know anything about federal Indian law either, but they found out about it, and wow, look, these Indians have all these rights. So they started bringing these fabulous cases, these Indian legal services programs, and we studied those while we were in law school, seeing the work they were doing, and wow, we need to really build on that. And it was just 7 of these programs, so most of Indian country still not covered by legal services. So we knew this national organization was really something that needed to be done. So when I graduated, I was lucky enough to hook up with some lawyers and Native American leaders to form the Native American Rights Fund. The National Indian Legal Defense Fund. We went to New York City, met with the Ford Foundation that had been funding the NAACP Legal Defense Fund, the Mexican American Legal Defense Fund. So they gave us a grant to start the Native American Rights Fund, so away we went. We had a board of directors composed of Native American leaders from around the country that helped us figure out what the priority issues were that we should address, because there's no way we could represent everybody, the tribes, Native organizations, individuals with important issues. And the board of directors set up, some priorities for us to address, and away we went. The first case we got involved in was an Indian treaty rights case, and of course, the Constitution of the United States, 1787 passed, and Congress has authority to deal with all the sovereigns, the foreign nations, the states, and the tribes. Tribes are sovereign governments, so there were treaties made with tribes. But what we were seeing there in 1967 and the early 60s, or late 60s, early 70s, was what the federal Indian policy was at that time, why nothing was happening, and that was this federal Indian policy of termination of tribes, forcing assimilation of Indian people, just ignoring our rights, not asking our people what we wanted. They were just doing this to us, and selling our land, shipping us off to the city, ignoring the treaties, and our Native American people got very active in the streets and taking over Alcatraz Island and getting all kinds of publicity asserting these treaty rights. And President Richard Nixon took notice of that in 1970, and he changed the federal Indian policy to reject the termination and assimilation policy and adopt a policy of self-determination, recognition of the treaties and the sovereign rights of the tribes. And it changed everything. And we took advantage of that as we started the Native American Rights Fund at the same time. And part of what we did is meet with federal officials back here and talk with them about their obligations under these treaties. Our land and our resources are held in trust for us by the federal government. The federal government is our trustee, and of course trustees have fiduciary duties. They're supposed to help us protect our land and our natural resources, and so we got them involved in doing that. They filed a case to assert the treaty rights of the tribes in Western Washington. Those treaty rights supported the subsistence, the culture, the religion of those tribes up there, which was based upon taking the salmon. Huge salmon runs up there, and they had always lived on the salmon The 1855 treaties that they made with the federal government said that the tribes retain the right to fish at their usual and accustomed places in common with the citizens of the state. And by the time we came along in 1970, the state had been asserting that the language didn't really mean anything other than you got to get a fishing license just like everybody else. And that's not what the tribes thought that language meant, based upon their history that had been passed down over the years. And so the federal government filed a case. We came in representing the tribes, intervening, and we were able to put the tribal leaders on the stand and talk about what that language meant in 1855 that had been passed down through generations, that understanding they had. And that was, the tribes, of course, started out with all the fish, and what they agreed to with that language was to share 50-50 with the settlers that came in and formed the state of Washington. And they could fish at their usual and accustomed places, even though they weren't on the reservation lands. And so the court accepted that testimony and eventually ruled in favor of the tribes that, yes, you get half the fish at the usual and accustomed places. And it just really shocked everybody up there in the Northwest that these treaties were being recognized as still the supreme law of the land. They were not ancient history. And this got appealed on to the Court of Appeals, eventually the U.S. Supreme Court, and those treaty rights to fish got upheld. And everybody across the country came to realize that these treaties were still in full force and effect. They weren't ancient history, and other tribes started filing treaty rights cases. We represented a number of them in their treaty rights cases, and away we went. We had other tribes come to us that needed help to get out of what had happened to them during this termination era. Some of these tribes had their tribal governments terminated, their land sold and everything, and this was a result of federal policy that started in the 1950s with the big communist scare. Well, some of these people here on the Hill thought that, well, we've got a bunch of Indians out there that are communists, and we need to get rid of these tribes. They're communal, they're communists. They started terminating tribes, doing away with them. And of course, these tribes continued to be tribal people, and survived in the 50s into the 60s, and then started coming to us and said, could you help us, because Congress had said this was going to be good for us, and look, we're the poorest of the poor, we're really bad off, and this promise of termination to help our people didn't work. So we represented the first one, the Menominee Nation of Wisconsin, coming back up here and helping them explain to the Congress the really devastating impact that this termination policy had on them, and it wasn't what Congress had thought was going to happen to them, and when they passed it in the 1950s. And Congress took immediate notice of that and said, sorry, sorry, sorry. So they restored the nationhood of the Menominee Nation. And these other terminated tribes started coming to us, could you help us? Because the same thing happened to us. This is devastating to our people. And so one after another, we brought those terminated tribes up here, and Congress restored their tribal status and got as much of their land back as they could, and away they went. And that termination policy was set aside completely. We had other big issues come up there in the early 70s that we helped with. We had the map put out by the Bureau of Indian Affairs, which had the tribes listed there and shown on the map. And of course, most of them, virtually all of them, in the West, and no tribes in the East. But these Indians show up on our doorstep there at our central office there in Boulder, Colorado, outside Denver, and they told us that they were Passamaquoddy and Penobscot Indians from Maine. And so we looked at the map, and there's no tribes in Maine. Who are you guys? And well, so they told us their history. Well, we've been here forever, and We used to have this relationship with the federal government. We have all these papers and everything, but the state of Maine came along in the 1820s and just took our land, and it's been the same ever since. The federal government never did anything to help us, even though, of course, we had relationships with the federal government, but they would not stop the state of Maine from taking over. And so, could you help us? Here's all our papers and everything. And oh, okay, we looked at them and all right, studied it. Well, there's this law that Congress passed shortly after the Constitution passed in 1787. One of the first laws Congress passed was the 1790 Non-Intercourse Act, which says states can't take land from tribes without the federal government's involvement through treaty and approval process. Has to be federally approved. And the state of Maine doesn't have any federal approval when they took the land from the Passamaquoddy and Penobscot. So, whoa. So what was your Aboriginal territory? Oh, they said about 2/3 of the state of Maine. Oh, okay, so we filed litigation, federal court, claiming 2/3 of the state of Maine for 2 tribes. And the court looks at the 1790 Non-Intercourse Act. Yeah, all this was illegal. This land is yours. It just shocked everybody. Of course, the state of Maine appealed, went to the Court of Appeals, and the Court of Appeals looked at it. And that's the law. Yeah, these tribes have 2/3 of the state of Maine. So, of course, we're all headed to the Supreme Court and see who gets 2/3 of the state of Maine. And we get a call from the White House, Jimmy Carter. Hello, this is President Carter. You guys ought to come to the White House and let's talk this over. State of Maine wants to talk it over, so okay. So we all come to the White House and the tribal leaders and talk with the state of Maine and agree to settle the case instead of having one big winner and one big loser. And so the tribes came away with a lot of land and a lot of money. Not 2/3, but pretty good chunk of it, and lots of money for the land that they had to give up. So next thing we know, here come some other eastern tribes. Hey, that happened to us too. We have the same situation as the Passamaquoddies and Penobscots. And so one after another, we started representing all these eastern tribes whose eastern states had come in and took their land with no federal treaties, no federal approval. So one after another, land claim settlements and recognition of these tribes back here as tribes. And so we've got a number of them back here. And all that was a result of the work that we did. We did many other big cases. So many of these issues had been ignored, swept under the rug for so long. We had a lot of these big cases, like I said, and it really took off. We did pretty well in litigation in these cases, beginning in the 70s into the 80s. There was one in particular that I should mention, probably the most significant Indian law decision in history, and that's the 1987 case involving the right of Indian tribes as sovereign nations to do gaming on their own land without any state interference, claiming state laws do not apply on our reservations. It's all tribal law and federal law. And that made it all the way to the U.S. Supreme Court, and the Supreme Court says, tribes, you're right, no state jurisdiction to regulate your gaming. You're sovereign nations. You can have gaming on your lands if you want to do that. So away they went, but not without a fight. The states came up here to Congress and said, hey, you have to take away this sovereign right of tribes to do gaming. And huge fight up here, and it resulted in compromise again. The Indian Gaming Regulatory Act allowed the tribes some role in this. They had to come up with compacts with the state, with the tribal governments to do the gaming, and the states were entitled to a little bit of the revenue to help deal with the law and order issues that might affect the states off the reservation. So they got a little chunk of the money, but the tribes could proceed with the gaming, and the states had to sign these compacts, and away the tribes went. And of course, these days, that's the largest economic driver in Indian country, is the gaming. Not all tribes are able to do that. It kind of depends on their location and everything, but for the most part, most of the tribes are involved in it one way or the other, and like I said, it's the largest economic driver in Indian country. We, like I said, did pretty well in all this litigation through the 70s into the 80s, but come the 90s, then things started changing a little bit as the makeup of the U.S. Supreme Court started changing, and became a little bit more conservative. We started seeing that the Indians weren't winning as many of these cases as they used to. Like I said, there was an inordinate number of these cases coming up to the courts because so many of these issues had been ignored for so long. But everyone started noticing that we weren't winning as many as we used to, and it really caused great concern among the tribes, because of course, they had really built this modern-day tribal sovereignty movement based upon the litigation. So that was a huge concern for them, and we had some discussion of that at the Native American Rights Fund. And one of the things that the board of directors had us do was start thinking about utilizing international law as well to fortify the rights of tribes to sovereignty in their land and resources, and culture and religious ceremonies and everything. And at that time, there were discussions going on at the United Nations about the possibility of a declaration on the rights of indigenous peoples. And the tribal leaders said, we need to start getting involved in that process with the other indigenous peoples from around the world. So we undertook representation of the National Congress of American Indians, the National Intertribal Organization, in that process at the United Nations. And after 8 years, we had some success in the United Nations with the passage of the Declaration on the Rights of Indigenous Peoples in 2007. And we were able to have that eventually signed off on by President Obama in 2010, where the United States recognizes the UN Declaration on the Rights of Indigenous Peoples and pledges to implement that as best they can. Of course, there were some reservations on that. They didn't completely endorse everything, but said they would try to meet that declaration. So that's been going on now, like I said, since 2010, and there's all kinds of meetings at the United Nations on the declaration, bringing in indigenous peoples every year. This permanent forum on indigenous issues held in New York City at the UN every year. We just finished, the 28th permanent forum up there. So that was very helpful. The impact of the more conservative court really got our attention in 2001, and that was a year when there were 4 Indian law cases before the U.S. Supreme Court that we should have won under the federal Indian law we knew, but we lost all 4. And that just totally shocked and devastated the tribal leaders who, again, had depended on the courts, in the tribal sovereignty movement winning these cases. And just to have the Supreme Court ignore or throw out or change federal Indian law like the way they did just shocked everybody. So the tribal leaders called a national meeting to address a crisis in Indian country, and that was called the United States Supreme Court. So we all came up here on 9/11/2001, started meeting, talking about these issues, and we had the chairman of the Senate Indian Affairs Committee, Daniel Inouye, there with us that morning, and he also served as chairman of the Defense Committee there in the Senate. And not too long after we started, some people came in and whispered in his ear, and he stood up and took over the microphone and said, I'm sorry, I'm going to have to leave the meeting because the United States is under attack in New York City and over at the Pentagon, and 9/11 was happening. And whoa, wow. Tribal leader said, let's get out of here. We need to go home and, do what we can to protect our people. And of course, the airports closed down, so nobody could go anywhere. So tribal leaders came back in. Well, U.S. sovereignty is under attack, and our tribal sovereignty is under attack too, so let's figure out what we're going to do about it. So we met for 2 days, and they decided what they would do is form the Tribal Supreme Court Project, following the model that the states had adopted just a few years earlier when states' rights were under attack. They had all the state attorney generals come in as part of a project to work on the states' rights cases all together, strategize together, figure out how to brief the case, how to argue the case, and see if they couldn't improve on states' rights being accepted by the Supreme Court. So the tribal leader said, we need to do that for our cases. So we set up this Tribal Supreme Court Project with the National Congress of American Indians to bring together all the tribal attorneys, all of the Indian law professors, all of the Supreme Court practitioners to really focus on each case that would come up and try to figure out how to brief it, argue it, and make it more understandable to the more conservative Supreme Court. It was very difficult to have to educate everybody out there in Indian country about the danger in the U.S. Supreme Court and really encourage them not to litigate anymore because we were going to lose. And so we had to kind of put a damper on everything. And the tribal leader said, if you need us to enforce that and go stop a tribe from doing something that's going to impact us all, just let us know. So everything had changed. So with this Supreme Court project started, we also started at that same time what's called a judicial selection project. The tribal leader said, well, how do these lawyers end up on the U.S. Supreme Court? How does that process work? And so we explained how, a justice is nominated by the president, confirmed or rejected by the U.S. Senate, and they said, we need to get involved in that process and make sure these people who are nominated to serve on the Supreme Court know something about tribes, know something about Indian law, and if they're against tribes, if they're against Indians, we need to go up there and lobby against their confirmation. So they got involved in that process about how these justices, get nominated and confirmed. So they've been involved in that process, and over the years, it's gradually improved at the Supreme Court. It's still very iffy, but still we're doing better than we used to, based upon the change in the makeup of the U.S. Supreme Court, and the tribal leaders continue to have us do that, and we're still through the Tribal Supreme Court project, just very cautious about cases that might be headed up there and how they're argued and briefed. But we have come a long, long way since 1970, when the Native American Rights Fund started, and we were facing this termination and assimilation policy. But we helped to implement this new self-determination policy. We've been at it 54 years now, and we have come a long, long way in terms of getting people to understand that there are three sovereigns in this country. There's the United States government, there's the state governments, and there's the tribal governments, 574 of them, 229 in Alaska and the other 300 and something down here in the lower 48. And we have A lot of support here on the Hill, really kind of led by the Senate Indian Affairs Committee that been in existence now for a couple of decades. We just really appreciate the opportunity to come up here and talk with people about tribes and tribal sovereignty, because as been mentioned, one of the biggest problems that we have is most people still don't know anything about us, and that's one of the priorities our board has set for us. Go out there and take advantage of every opportunity to educate people about federal Indian law and policy. So this was a good opportunity to do that, and I really appreciate that, and glad to take any questions that you might have. Thank you.
Again, the cards are circulating, and Jennifer is going to lead the questions. So you could start with your own.
Yes, thank you. Thank you, John. That was incredible. I just listening to everything you had to say, and just the origins of the Native American Rights Fund, and how you've really been at the forefront of every single leading policy change, whether it's in the courtroom, in the halls of Congress. It's just so incredible. So thank you again for your leadership, and for educating us today about just how far we've come, but actually just how much further we have to go, frankly. I think one of the questions that I have for you, and maybe it's just an observation, but from the sort of humble origins of the Native American Rights Fund as sort of this Indian legal services organization to what it evolved into as the Native American Rights Fund. And I have to say, we're coming up on the 100th anniversary of the Snyder Act, which is also known as the Indian Citizenship Act of 1924. 100 years since Native Americans were actually, it was acknowledged that they had the same rights of their fellow Americans to vote. And in fact, the states didn't actually implement until well after that time. And so my grandparents, for instance, couldn't vote, even though they were born original indigenous people of this country. So we've come a long way. There's a long, long way to go. But I do think that the question of voting is something I think is top of mind right now. And I know, John, you've been really finger on the pulse for, the rollbacks after the Shelby case, and how it's just harder for natives to vote, whether it's, using their own tribal ID to register, or to actually, exercise their right to vote. It's not as easy, or it's very difficult, and it isn't as easy as it should be. So what other roadblocks do you see? I mean, what can we do in Congress? How can advocates really engage and amplify? And because, as you pointed out, the conservative tilt of the Supreme Court isn't frankly helping. So what else can we do from your perch? I know as a litigator and as a policymaker, but particularly as a congressional staffer, I'm very interested in learning what more we can be doing, frankly, to make sure that natives continue to exercise their right to vote.
The voting rights issue is very serious these days, again, thanks to the United States Supreme Court. This Shelby case that we mentioned there is something that happened in 2013. The Supreme Court, in interpreting the Voting Rights Act, declared unconstitutional a key provision of that Voting Rights Act, and that was what was called pre-clearance. The Justice Department had the right under the Voting Rights Act to look at all of these changes in state law that affected voting rights, and if they found that these state laws were unconstitutional, and they could just declare them unconstitutional, and it was over. The Supreme Court knocked out that provision. So there's no more pre-clearance. The states passed these laws discriminating against minority voters, including Native Americans, and they could just go into effect. They didn't have to be pre-cleared anymore. And So, these states started passing these discriminatory laws, and they were impacting our Native American people, and our Native American people wanted to bring lawsuits to knock down these discriminatory voting laws, and of course they needed lawyers, so guess who they started calling? And so all of a sudden we got involved in a whole bunch of voting rights litigation. We weren't the only ones impacted. This affected all minority groups, so we work with the other civil rights organizations, the NAACP Legal Defense Fund, the Mexican American Legal Defense Fund, ACLU, and trying to address these issues and get funding from foundations to help us fund this voting rights litigation. So we've been very heavily involved in that since 2013, since the Shelby County decision. It's something that we've, for the most part, been successful at because these laws are discriminatory, as Jennifer was talking about, in just a number of ways. So we have done well, generally speaking, in that litigation. Of course, in 2020, they did the census, and based on the census, then there's a redistricting process that goes through, and the districts are redrawn, and we hope through that process to get fair representation of Native Americans in these districts. But again, some of these states gerrymander these districts where our Native vote gets really diluted and we're not able to elect anybody that we like. And they do that on purpose. And so we're involved in a whole bunch of lawsuits dealing with the redistricting that really tries to dilute our vote. And again, as Jennifer was talking about, since 2013 and all of these issues going on, we need to fix that Voting Rights Act. So we have put together what we call the Native American Voting Rights Act, and working with the National Congress of American Indians and a number of other Native organizations across the country, trying to get this Native American Voting Rights Act passed to address the specific issues that impact our people when they try to vote, and all the issues raised in that litigation that we're involved in across the country. And it's pretty tough going up here on the Hill on these voting rights issues right now, but we never give up. We were talking year after year, this legislation gets introduced and we push it as hard as we can, but not quite over the hump yet. But we never give up, and hopefully one of these days we're going to prevail.
The Native American Voting Rights Act is a bill that I've had the privilege of working on for some time now. And while it is frustrating that we haven't been able to sort of get it across the finish line, I mean, it's a bipartisan, bicameral bill, and it really will, improve Native American voting, not just voter ID and registration, but also access to the ballot box. So I do think, though, that while we've had some challenges here on the Hill, and states have a long way to go as well. Just doing a little research on my own, I was thinking to myself, well, what are states doing, especially those states in the West with larger Native populations, what are they doing to really address suffrage for Native Americans? And I was very surprised to learn that 13 states have their own laws that allow tribal IDs to be used for registration. 20 states allow tribal IDs as a form of ID for voter identification. And these are not small things. I can take my tribal ID to the ballot, the voting registration in my precinct, and I won't be asked for my driver's license. That's no small thing, especially for more rural communities who simply, they don't have that form of ID. What they do have is, acknowledgement and recognition by their own tribal government. And that is a government-to-government relationship that I think that John is fighting for every single day, and for tribal advocates here in DC, and we try to preserve. So I think it's just really important to kind of underscore that suffrage for Native Americans is not something of the past. There are challenges that exist, and federal law needs to be changed to make access easier to the ballot box. So pivoting to, I got a question from the audience here, and it's about subsistence rights. And John, you mentioned earlier that the Bolt decisions and the Washington State litigation. The question is, what current challenges and legal challenges do you see with Indigenous subsistence rights, and how do those struggles relate, I think, to the struggle for Native citizenship?
Well, it's something that continues to come up, particularly in Alaska. Subsistence hunting and fishing rights are so important to those 229 tribal villages up there, because that's basically the way they live. That's their grocery store, and they have rights under federal law, priority rights to hunt and fish there on federal lands in Alaska. And it's one of the issues that we've been working on since the 1980s. We set up an office there in Alaska to work on these issues for those tribes up there, and we prevailed in the litigation for years and years. It was posed by the state of Alaska, and we prevailed in what was called the Katie John decision. So we went all the way to the Supreme Court, and when the Katie John decision, subsistence hunting and fishing rights for Alaska tribes is legal. That's the law of the land. And so does that change what's happening in Alaska? No. State administration after state administration starts the litigation all over again, challenging the subsistence rights of those tribes up there. And so it goes on and on and on and on, and we're again involved in the latest episode of that right now, and it's just unbelievable how they never give up and just keep coming back. And again, they are taking notice of what's happening in the U.S. Supreme Court, the change in the makeup of the Supreme Court. So they just hope that one of these days they'll get up there and the court will change its mind and do away with subsistence hunting and fishing rights for those tribes in Alaska. It's just strange part of this political process that I was referencing earlier.
Absolutely. And speaking of the Supreme Court, there's a question that came in about the 2020 McGirt case. That's McGirt v. Oklahoma. And essentially, the United States Supreme Court determined that the eastern portion of Oklahoma was never diminished pursuant to Oklahoma's, the treaty rights of those particular tribes. I think for purposes of criminal jurisdiction, that's a landmark case. But currently, with the composition of the Supreme Court, do you have any insight with respect to where we're going here?
Well, the McGirt case was really kind of a landmark case. The Muskogee Creek tribe prevailed 5-4 vote, based upon the principle of federal Indian law that we understood very well, and that is, a reservation is established and it stays a reservation until Congress somehow disestablishes that by specific language, specific laws. And so the Supreme Court looked at the argument by the Muskogee Creek Nation that said our reservation boundaries are still intact. The Congress has never changed the reservation. We still have jurisdiction over all of this land within our original reservation, which includes the city of Tulsa, Oklahoma, and a lot of other places. And the Supreme Court looked at all the legislation and everything that's happened there in Oklahoma and said, yeah, Congress has never disestablished that reservation. Those boundaries are still in effect, so that tribal jurisdiction still in effect on that original reservation. And since then, it's been expanded to 4 other tribes that also had similar laws like the Muskogee Creek Nation. And so about a third of Oklahoma now is within Indian reservation boundaries. And that was, again, a tribute to the U.S. Supreme Court upholding federal Indian law. You know, that's the only way to diminish the reservations is Congress has to pass an act. And people just can't assume that, you know, this and that happened, and so, you know, that the reservation jurisdiction's gone. No, it's not, until Congress specifically says that. Great decision, upholding federal Indian law. That's what we need.
And may it continue. I think we have a few minutes left. I think, well, it just got me thinking, being here in the Kennedy Caucus Room. The last time I was here, it was on the Artificial Intelligence Forum, and you had Bill Gates and Mark Zuckerberg and a number of other, you know, tech gods, as you will, luminaries, talking about, you know, the impacts of AI on all of what we do here in Congress and in fact, the country. But what wasn't discussed was the impact of AI on Native Americans and tribal self-determination and self-governance. And I know that this is a very nascent area of the law, so I don't want to put you in the spot, John, but it's something that the Senate Committee on Indian Affairs is very interested in exploring. You know, everything from, you know, how can AI actually help with tribal criminal jurisdiction, public safety issues. We just had a hearing about that yesterday in the Indian Affairs Committee. What are the challenges? What are the obstacles? What can we do to actually, you know, leverage that technology? And because we're talking about suffrage, how can we leverage that technology to actually help the Native vote? You know, I know that there's a lot of sideboards here, and they're very, very, very smart people thinking about these things. But it just occurred to me that, you know, having you here and being a, you know, preeminent scholar in Indian law, you know, AI is sort of uncharted territory. And I do think that there are a lot of opportunities for Indian country to benefit from AI, but there are also a lot of risks. So I wonder if you have any thoughts on that.
Well, I'm not a technology expert, that's for sure. But there is this emerging issue of data sovereignty. Tribes using their sovereignty to control all of these data issues, and one of those that's currently pending that we're involved in deals with the effort by the state of Montana to do away with TikTok. And of course, as we've talked about earlier, you know, state law does not apply on the Indian reservations, so state can't ban TikTok on the reservations. And of course, that gets into all these technology issues where how do you control that with, you know, the airwaves going on and all this stuff, and you know, how's that impacted by the jurisdiction? And so the Ninth Circuit Court of Appeals is going to have to figure it out. But we've weighed in on behalf of the tribes asserting this argument, you know, data sovereignty, and tribes control that, and we'll see what happens.
To be continued. All right. With that, thank you very much. Thank you, John. It was a pleasure.
Good.
We have special gifts for each of you. This is a
Thank you so much.
It's a paperweight made from marble from the Capitol that depicts the Capitol, so you can remember this visit. And we are so grateful for you being with us. We have a very special treat.